So one of the interesting things about this case was that our client actually rear-ended the defendant. And in that kind of a case, you do have a little bit of a challenge because a lot of jurors are going to see that it was a rear end and our client's the one that did the rear ending, and immediately that bias kind of kicks in and they think, well, when you rear end someone, that's your fault, right? And there's actually a jury instruction here in Colorado that talks about the presumption of negligence when you are rear-ending someone. So it created a little bit of an odd dynamic. Now, the investigating officer did note and did cite the defendant driver for not having his hazards on and for not putting warning triangles out. He was driving a truck, a delivery truck. And when you have that situation where you have a defendant who's at fault, but they have a wedge issue and an angle to try to point the finger back at your own client, you really have to go out of your way to find the pressure points in the case, to kind of like really put them on their back foot and really press the buttons so that the focus is taken off of any potential wedge issue they do have. So in this case, I really did something that I tend to do in a lot of my cases, and that is use the deposition of the defendant driver to really capture testimony or ideas or thoughts that they have that are clearly unhelpful to their position, and also polarize the case. And when I say polarize the case, I mean they make statements or comments that really make even the most untrained legal mind, from a common sense perspective, a potential juror think, why would you say that? That's a terrible thing to say. And that allows you to shift the focus back to the at fault. So in this case, when I took the deposition of the defendant driver, walk him through some of the training and the materials and some of the things that he'd been provided, by his company in terms of training, and really press him on his own understanding and thoughts about what he should have done and what he would have done if given another opportunity. And that is a really fun question to ask defendants, because oftentimes defense attorneys don't really counsel their clients properly. And this is an area in which I've found a lot of success, where you ask the defendant, let's hop in a time machine and go back to right before the crash. You get a second chance at this. What are you doing differently? And the gut response a lot of times is nothing. I was doing the right thing, or I was driving safely. And you don't just leave it there. You really walk them down the path. You wouldn't change your behavior. No. You were driving safely. Yes. In fact, if you could hop into that time machine to right before the crash, you'd do it all the same way. Yes. Because once they've committed, they're pot committed, so to speak, and they're going to keep supporting their own line of logic. And what they don't realize, and what the defense attorney is likely realizing in the moment, is that you've now established a basis for punitive damages. That is to say, he understood the conduct wasn't appropriate and really doesn't care that he did it and would do it again if given the opportunity. And punitive damages are intended to deter future bad conduct. So in that kind of a situation, if you use the deposition, to your advantage and you really deploy some appropriate questioning methods, you can get that kind of evidence, as we did in this case, which allowed us to ask the court to amend the complaint to add punitive damages, which they did. And that creates a whole nother level of threat for them. It creates potential conflict between the defendant corporation, the defendant driver. It could require separate counsel be assigned for the driver. And it creates kind of a pitting against one another in the background that's really helpful in terms of leveraging them when it comes time to settle a case or to demand money or comes time to trial. It's a great way to have both defendants essentially throwing each other under the bus. So that's one thing that we used in this case that was really effective and really just created a lot of drama for the other side and a lot of really good leverage for us.